May prelude. In item 9, my lord. It is required to file an affidavit. Last time it took time, my lord. Last time, my lord.
Yes.
DML, I'm going to file an affidavit, my lord. So let me come after 1 week.
You are for the appellant?
Yes, my lord.
Then
I'm going to
counsel,
respond.
okay. Counsel for the appellant states that he would be filing the affidavit during the course of the day.
Yes, my lord.
List after summer vacation then.
My lord, on 21st June, my lord. 21st June, my lord, list.
Not possible now,
Yes, my lord.
after summer vacation.
Make please, item number 8, I pay for an adjournment, my lord. Well, this is a review petition. I appear as the amicus curiae. On the last occasion, my lord has called the
The
petitioner.
petition is not
He's
here.
not well. He's a old man, my lord.
Amicus curiae, Mr. Mantha states that he has contacted the petitioner, but since he is unwell, he is unable to attend today's hearing. List of summer vacation, date de dena koi. List on 26 July.
May I please, your lordship, I beg to mention item number 14 with the consent of the opposite party. Lordship, the arguing counsel is not well today, so the matter could not be conducted.
Counsel for the appellant has circulated an adjournment slip. The other side has no objection. List of summer vacation. Like,
May I please, your lordship, I beg to mention item number 17. We are seeking accommodation only for the day, your lordship. The matter may kindly be fixed on Wednesday.
why then let it come after vacation then,
Okay. Much obliged.
after summer vacation has been. Yes.
Lordship, item number 27, I
Mhm.
could not file the affidavit in reply as the petitioner has taken his mother in Chennai for treatment purpose.
And counsel for the petitioner pays for and is granted 4 weeks time to file. So as to enable the petitioner to file the affidavit in reply. List up to 4 weeks.
Obliged, please.
Very clear, lordship. So in item number 28, lordship, the appellant has filed an additional affidavit, lordship. So I want to file a reply, lordship. A short date will be given, lordship.
Lordship,
I
and
can
for the
counsel.
appellant. Lordship, before vacation, any date may be given.
Yes, yes.
And counsel for the respondent submits that he needs short opportunity to complete his instructions. List on 27th. What is the urgency? What is the urgency?
Lordship, the person has been creating nuisance in this.
Oh, list on 19th July.
Right.
Right, your lordship.
May I please, your lordships? Your lordships, as regards item number 31, your lordship. Your lordship, on the previous occasion, your lordship, the appellant has sought time to file affidavit in reply, your lordship. Your lordship, we have sent the affidavit in reply for vetting. Your lordship, let the-
Counsel, Mr. Your good name, please.
Your lordship, D.S. Decca, your lordship.
Yes, the states that the affidavit in reply has been sent for vetting and some more time is required to place the same on record. List up to 4 weeks.
Much obliged, your lordship.
Please, your lordship, with consent of others, I beg to mention item number 35, lordship. Let it come after vacation, lordship.
Hearing matters, give a date, whatever anyone requests date. Give a date in August now. Whosoever wants a date. Okay. Right.
May it please, your lordship. As regard item number 39, my lord,
Yes.
I need to file additional affidavit bringing on record my subsequent.
Counsel for the appellant, place for and is granted.
Lordship. They are taking time always, my lord.
Oh, this
Because
is
they are
an-
enjoying the stay order. Lordship, may granted liberty to complete the DP
No,
because DP has been stayed.
that your lordship may hear because matter is fixed on hearing, in hearing. And
All right, then argue.
Yes.
They have an objection.
my lord, they have objection, but by order dated 24/5/2023, my lord, disciplinary authority who has filed affidavit, they have not filed. Revoke my lord suspension by noting that the inquiry officer proceeded against the order passed by this honorable court. So that I want to bring on record. Your
Counsel for the appellant prays for and is granted short opportunity to bring some new facts which have come into be existence during pendency of the appeal on record. A list on 17 July,
Deeply obliged.
deeply.
the requisite documents be brought on record in the meantime.
No, but other respondents, they have not filed an affidavit.
That's their choice.
Mine,
We can't compel them.
right?
Lordship, I would like to mention item number 40 of today's list, Lordship.
Mm.
My lord, may I pay this matter may be taken up any other direction to the Lordship.
Any objection? List after summer vacation.
Much obliged.
Yes.
Please, your lordship. Your lordship, I beg to mention for listing.
Listing. What is the matter?
Contempt.
Contempt. 13th, 14th, 13th.
Along with item number 45, the 15 may be taken up. Along with item 45, the item 15 may be taken up.
Then when it is called out, we'll see.
Same issue.
15 साथ में लगा देना.
Mr. Lordship, we have filed a affidavit in connection with item number 12 and 15, my lord. Maybe call for me.
मंगा लीजिएगा affidavit. Call the affidavits. Yes.
Public.
May I please, your Lordship? Lordship, I am praying for listing of a writ appeal which was filed on 18th of May.
Hmm.
Lordship. It may come any day
14th.
next week.
14th.
Obliged, your Lord.
Supplementary list, item 46 and 47.
We have received written instructions for this morning. that I have received. It's like not paid, make it receive.
Pray for not giving stay.
My lord,
Pray for not giving stay. You are
Lordship,
communicating this,
yeah,
passing on this communication to us.
my lord, your lordship will kindly see clause 2.
You read,
Clause 2, my lord.
we have read that. First, you read the letter which has been placed on before us.
My lord,
Read the,
but I flagged, my lord, the second page, my lord.
but you have given the letter also to us, sir.
Well, that may be ignored. The government will file its reply soon within the given timeline and case may be decided on merits thereafter. No appointment will be made till the end of this month, which is reasonable period for hearing of the case on merits.
All right, we have considered that. Anything else to say?
That is otherwise, I have argued, my lord, that please something more.
Yes, okay. So you want us to pass an order on merits or not now? Again, the same query.
Well, that hearing has to be done, man.
That's, we asked you, you sought time to complete that instruction only. That you want an order on merits or not?
Well, at this stage, man, limited, man, because your lordship is probably remanding the matter back to the single judge, man.
So that's what we are saying,
Yes.
that on the prayer for interim relief, you want us to pass a reasoned order because now you have come out with the case that no, the state is opposed to the stay being granted. Then we will have to pass a reasoned order. That may, of course.
So your lordship will kindly notice this, my lord, the instruction, my lord.
We will not do it
That-
till, what is this?
Till end of.
You
this-
could have said that we'll keep it in abeyance till the writ is decided. Why were you not very clear on that?
My lord, one problem is.
What is the guarantee that the writ will be decided before the end of the month?
My lord, no, my lord, this is there, my lord. This your lordship will kindly record, my lord. This your lordship may record, my lord. That will not.
Are you prepared to go further and say that yes, all right, the process will not be completed or carried forward till the writ petition is decided?
No, my lord, the matter is fixed within this time, my lord. before
Mr.
the
Goswami,
for hearing, my lord.
Can you give an assurance
Yes, my lord.
as a seasoned counsel of this court that the writ is going to be decided within this month?
Matter.
Yes,
My lord,
writ petition.
Yeah, writ petition is fixed there, my lord.
Oh,
We are
fixed.
filing the affidavit. Already
There are-
parawise
there are
comments has been
N
sent.
number of matters fixed in this court
No,
today.
no, my lord. The parawise comments have been sent already, man. That is, my lord, not here, but.
We understand what you are trying to say. We'll pass a reasoned order.
Your lordship may fix a date before the line.
What for? We can't bind the learned single judge on how to proceed with the matter. It's the discretion of the court hearing the writ petition.
The order, they have granted us 2 weeks time, my lord. Even that is within this period, my lord. So by the
Swami,
time-
probably we are not very clear to you. That is the difficulty. Can we bind the learned single judge to hear and decide the matter in this month itself? We'll let you know of an instance. There was a detention matter in Delhi High Court. In those days, the detention matters were taken up by single bench. The time there were so many detention orders that there was a special bench for hearing those matters. The detainee had spent about 10 months. A request was made, please hear my writ petition, otherwise it will become infectious.
My lord.
That prayer was dismissed. It went to the Supreme Court. Supreme Court passed an order. We request learned single judge of Delhi High Court to decide the writ petition at the earliest. The learned single judge writes back that I am not bound by the request of Supreme Court. Again, the matter went to the Supreme Court. An honorable Supreme Court said, yes, the learned single judge is correct. So we do not have supervisory jurisdiction over a single judge of this court.
For my lord, your lordship may direct the parties to make a prayer, my lord, and the matter is urgent, my lord, so we'll do that. My lord. To have it heard within this time, my lord.
That is your choice. You want to have it heard, get it done.
My lord. That liberty, your lordship.
Mr. Goswami, we are simply asking you a simple query. You want us to decide this appeal by a reasoned order as to why we are granting stay, which might have an impact on your writ
Exactly,
petition.
my lord, that may influence the.
That-
my lord.
So you are compelling us to do that. Then we'll do it. We gave you this time only for this purpose.
My lord, I
that
am
you could-
making a prayer.
You
on
could
behalf of the-
come up with a reasonable kind of offer.
My lord,
Session.
that is the clause 2, my lord, that we are not taking any steps, my lord, and within that time, in fact, we'll make a prayer.
Okay, very well.
that the matter be heard before the.
Take down. Then this writ appeal, intra-court writ appeal is directed against the order dated. And now please don't try to interrupt us in the midst of the dictation of the order.
No.
Whereby order dated so and so, whereby comma, the learned single judge, comma, denied the prayer for interim relief made by the appellant's writ petitioners in the writ petition. The appellant's writ petitioners are duly selected chairperson and member respectively of the,
Both are member, my lord.
both are members, APSC, members of the APSC, APPSC, pursuant to a selection held as a consequence of the advertisement dated 21/11/2022. Needless to say that before that, right, the selection was completed and an order dated, where is the order?
My lord, page 69, my lord.
Order dated, notification dated 7th February 2023 was issued by the government of Arunachal Pradesh in terms of Article 1 of the Constitution of India, read with section clause 4 of the Arunachal Pradesh Public Service Commission Regulation, whereby, comma, the governor of Arunachal Pradesh was pleased to appoint the appellants herein as members of the APPSC. It was clearly indicated in the order that the appellants shall hold the office for a term of 6 years from the date on which she/he enters upon the office or till she/he attains the age of 62 years, whichever is earlier, in terms of the provisions of clause 2 of the Article 316 of the Constitution of India. It appears that before the selection, as stated above, was held, comma, there were large-scale protests in the state of Arunachal Pradesh owing to irregularities in the manner in which the erstwhile APPSC, comma, conducted certain selection processes which had to be scrapped. Full stop. It is only as a consequence of the erstwhile members of the erstwhile commission were arrested. What has happened to the earlier
They
commission?
were not arrested, but there were wide,
No,
they
46.
resigned also.
46
46.
arrests were made, my lord.
It is stated that what happened to the earlier members? Their tenure had come out.
Earlier members, my lord. That
No, but their tenure had come to an end. Earlier members.
No,
Then
they resigned. my lord.
they resigned.
the earlier members of the earlier commission,
And
comma,
candidates were
resigned
Okay.
as a consequence of these protests and large scale arrests
Yes.
made in the state, which comma resulted into the fresh selections being made as above. However, even before the appellants herein could start functioning, comma, the state government, comma, issued the when the swearing in ceremony of the appellants was fixed at 17th February, on 17th February 2023 at the Darbar Hall, Raj Bhavan, Itanagar. However, before the swearing in ceremony could take place, comma, the same had to be cancelled because of law and order situation prevailing in the state. First up, the cabinet took a decision on 18/4/2000. Cabinet of Arunachal Pradesh took a decision on 18/4/2023, whereby, comma, the appointment of the appellant's hearing was recalled. First up, a fresh advertisement was issued for filling up the posts held, posts on which the appellants were appointed on 28/4/2023. Being aggrieved of the fresh advertisement for selection of members of the APSC, comma, the appellants preferred WPC number so and so before the learned single bench at Itanagar, rate petition number so and so at Itanagar bench of the Guwahati High Court. The learned single judge, comma, declined the prayer for interim relief by order dated 8/5/2023, while observing that the issues involved in the writ petition requires some deliberations. First up, the said order dated 8/5/2023. There's a common order
No, my lord.
First,
8/5/23 in writ petition number so and so, and 22/5/23 in 29/5/23 in so and so, whereby prayer for interim relief has been declined.
But my lord, it was directed that the appointments made pursuant to the advertisements would be.
Sir, we requested you not to interrupt, please.
My lord.
Decline, while observing that the process initiated pursuant to the advertisement dated 28/4/2023 shall be subject to further orders that may be passed in this writ petition. First up, the said order whereby prayer for interim relief has been declined to the appellants is the same in these two writ appeals. That senior counsel, Mr. K. N. Chaudhary, and in appeal number so and so, and Mr. Mazumdar in appeal number so and so, have drawn the court's attention to the provisions contained in Article 316 and 317 of the Constitution of India. They urge that once the appointment is made of the members of the Public Service Commission in terms of Article 316 of the Constitution of India, comma, the removal oblique suspension, the only process by which, comma, the appointments can be nullified is by resorting to the procedure provided under Article 317 of the Constitution of India. They urge that the scheme of Constitution, comma, does not contemplate for withdrawal of the order of appointment. They thus urged, they further submitted that the observation made by the learned single judge that the process initiated pursuant to the advertisement dated 28/4/2023 shall be subject to further orders, comma, would not in any manner resolve the situation, because in case appointments are made as a consequence of the fresh appointments are made as a consequence of the second advertisement, which is illegal on the face of record, comma, third party rights will be created, and again the bar of Article 317 would come into play. They thus urged that until and unless, comma, the writ petitions filed by the appellants challenging the cancellation of their appointments are decided, comma, the fresh process for selection deserves to be stayed. They further pointed that the reason as assigned by the respondents for cancelling the appointment of the appellants as indicated in the affidavit of the respondents is that there was a large scale public protest on the
Page 85.
as indicated in the answer given by Honorable Chief Minister Arunachal Pradesh to a question posed in the assembly proceedings, was that there had been protests and agitations by submitting a memorandum wanting that there should be a constitution of new selection committee and that there should be a new selection process for appointment of chairman and members. Thus, comma, merely on popular demand, comma, the appointments already made were cancelled. Learned, it is contended that the procedure so adopted is alien to the scheme of Constitution, and hence, comma, it was further submitted that there is no aspersion whatsoever on the bona fides of the selection process in which the appellants were selected as members, and hence, comma, the flimsy reasons on which these selections have been cancelled cannot stand to scrutiny. Post up. Learned counsel for the respondents have vehemently and fervently opposed the submissions advanced on behalf of the appellants. They urged that as the appointed members, that is appellants herein, had not taken oath, comma, they could not be termed as duly selected members of the commission. Oath in terms of the clause so and so of the APPSC regulations 1988. They thus urged that no right to hold the post was crystallized in favor of the appellants herein so as to give them the locus to challenge the well-reasoned decision of the state government in cancelling the appointments. That is your argument, Mr. Goswami.
Fine.
We have considered the submissions advanced at bar and have gone through the material available on record. At the outset, we may note that the scheme of constitution, particularly Article 316, to be specific, Article 316 clearly stipulates that the appointment of the chairman and other members of the Public Service Commission shall be made by the president, shall be made in the case of state commission by the governor of the state. Thus, the appointment order dated so and so having been issued by the governor of state, the same is deemed to be an order under Article 316(1) of the Constitution of India. Merely because there is a the issue as to whether the administration of oath under clause 4B of their APSC regulation 1988 would only make the appointment of the members complete is a matter to be deliberated before the learned single bench. Any expression of opinion by this court on this issue at this stage may prejudice the case of the respondents. Hence, however, allowing the new process to continue would lead to grave complications in as much as, the freshly selected candidates then again, would try to take recourse to the provisions contained in the Constitution of India. In any event, we are of the firm opinion that the existing set of members, unless duly removed by taking recourse, in any event, we feel that a question is required to be adjudicated that whether an existing duly selected members of the commission can be removed by taking recourse to the action of so-called cancellation of appointment. Hence, we are of the firm opinion that until the writ petitions preferred by the appellant are decided, the fresh selection process cannot be allowed to continue. Hence, the prayer made by the appellants in these two writ appeals are accepted. The take one more line. It may be stated here that there is no averment on behalf of the respondents in this writ appeal that the selection process by which the appellants were selected was tainted in any manner. Is there any allegation? Is there any allegation?
We don't have any.
Yes, all right. In this way of the matter, it is hereby directed that until final disposal of the writ petitions referred to supra, the fresh selections sought to be made by virtue of the notification dated 28/4/2023 shall remain stayed. The writ appeals are allowed in these terms. We make it clear that the observations made herein above shall be restricted for the purpose of, shall be construed for the purposes of these two, disposal of these two appeals, and will not have any bearing on the outcome of the writ petitions.
Daily list for orders, item 1.
Yes.
May it please your lordship, my lord, there was a leave application, IA Civil 445/2019. And my lord, they have filed an objection. They have admitted to all other facts, but only one laches was there on our part. My lord, during the, we have filed one.
You had filed an application during the writ petition,
Writ petition.
which was rejected, which was not challenged.
Not challenged.
So then how you can file an application now here?
My lord,
That right has been, that issue has been foreclosed.
Because there was a leave application for review.
So in
That
that
was-
leave application, you are not found entitled. How can you maintain an appeal?
My lord, because learned single judge has observed that because the state has filed a review, the review was dismissed. Hence, this IA.
Where is the order of dismissal of review? Please read
My lord. This is that.
of your application review.
That is at page, my lord. It starts
Page
at page
41.
27.
27.
My lord, in the last paragraph, page 28, last. According to this court is of the view that the present application praying for leave to grant a file a review of the order dated past in WPC cannot be allowed. Further, this court by the order has already dismissed review petition which has been filed by the state government.
Mr. Counsel, to read the para above that. Her right has been recognized by learned single bench.
My lord,
Read, please. We are asking you.
third line, though the court finds.
In view of the facts, yes. Though the court finds that the writ petitioner should have, you have got a copy or not?
In his application. His objection.
We know, that's why we are
Yes,
asking
my
you.
lord.
Read page 28,
Yes. my lord.
thus, last but one para.
Huh.
In view of,
In view of the above facts of the case, now this court finds the petitioner should have been implemented.
so the court holds that the applicant should have been made a party.
Yes, sir.
So then if that is the finding,
Finally, what said by this honorable?
finally, because the state's review was dismissed, her review was not entertained.
This is his which case, my lord, order, your lordship, my lord, either the review petition.
So these are contradictory observations, sir.
In the review.
These are
petition,
contradictory observations. The observations are contradictory. On the one hand, learned single bench holds that you should have implemented her a party.
This order has not been challenged, my lord.
Doesn't matter, doesn't make any difference. That was only for review.
Your lordship may kindly say the review order, the government
Oh, read even the para above. The applicant was appointed as Anganwadi worker, so and so. Petitioner made a challenge to the dismissal order, so and so. Though this court finds force in the submission made by the applicant's counsel should have been.
Made part.
So your removal was found to be illegal.
Yes.
She has a right to challenge it. And if the appellate court in the appeal it is found that no, your removal was correct, then she gets a right of appointment.
But yes, the final decision with regard to the grievance to the repetition will be related to the termination of the order. Dated 14/7.
Yes, what is the consequence?
Yes,
So
my
what is the consequence of the termination order being interfered?
the termination order is 14/7/14.
So what is the termination, what is the finding on the termination order, Mr. Chaudhary? Mr. P.K. Rao Chaudhary,
My lord,
what is the finding on the termination order?
my lord, the finding was that, my lord, there was an inquiry and in the inquiry it was held that it was, my lord, he was not.
So you are basically trying to reap the fruits of her dismissal.
Because
As such, you had no right as against her.
because during that interim period, there was a selection I was appointed.
Maybe. So that was only contingent to her being removed.
My lord.
Then we are not inclined, sir. Dismissed.
So,
Objection.
Item number 2.
Yes.
Lordship, here, we have,
Service has been effected.
yes,
So respondents are represented.
yes, madam. We have
And now, what is this application about?
Lordship, there is a delay of 583 days.
So how is it, how the delay has been explained?
Lordship, paragraph 2, Lordship. It's a known method, Lordship. I can't say much.
Then we'll dismiss your.
But Lordship, there is one part because in the order of the single judge, the suspension order of the respondent has been interfered with. But paragraph 15, Lordship, wherein it is stated that SIP secretary should issue a notification monitoring whether the charge sheets are issued before the 3 months as laid down by the Honorable Apex Court. But in some cases, Lordship, the disciplinary authority is either the governor or the chief secretary. If it also directed that if someone is in default, then departmental proceedings should be initiated against them. We are against that part only, Lordship.
But what to do?
Yes,
How-
Lordship.
There is that, the delay is gross.
Yes, Lord. Lordship.
IA for condonation dismissed. No reasons assigned.
And Lordship, with regard to that other part of the Lordship last order, steps have been taken.
Compliance, it's steps, we know. Section 5 rejected. No explanation at all. That is- Madam, first. Okay,
Item number 3 to 6.
street vendors. What has happened? Respondents, Mr. Naik, you were supposed to file something.
Lordship, yesterday I received one instruction, Lordship. They have mentioned about 7 points, Lordship. The way it has been,
Don't you think that the proceedings are going very slow?
Lordship, at this moment, Lordship, they are concentrating for constituting the town vending committee, Lordship. It has already, earlier term already expired, Lordship.
Okay,
Presently, that is going on, Lordship. Once that
how long will it take?
Lordship will take, if your Lordship take up this matter after 4 weeks, Lordship, then we'll be able to.
Mr. Naik
concrete, Lordship.
are appearing for the respondent submits that the process for that the process for identifying the vending zones in terms of the order dated 3/3/2023 could not be completed because the existing term of the existing town vending committee expired in the meantime, and a new committee is in the process of being formed. He prays that 4 weeks time may be allowed so that the things can be taken forward. List after 4 weeks. Yes.
Lordship. Obliged.
Item number 7.
Very clear. As per last order, my lord,
NHEDCL, you have impleted? Implement has been done?
yes,
Okay.
notice served, notice is served, my lord.
Hmm?
Notice also
Notice.
served.
Who is appearing for NHEDCL? You are appearing? So what?
Regarding that instruction, my lord, last. I had received his instruction,
Hmm,
that particular road, which is in question now,
yes,
that is not constructed by NHIDCL,
it's not being constructed.
not brought back.
Then who is doing it?
That because
Which is the agency?
that will be, he has to verify because it is from Meghalaya.
Your statement is that NHIDCL
DCL
is not doing it. Then,
Because I have,
and Ms. Counsel, if this is in Meghalaya, why we have the jurisdiction?
This is not in Meghalaya only, my lord. It covers Assam also, both the states.
But then
Therefore,
now that is a statement that NHEDCL not doing it.
But
Yes.
let me take to your lordship page number 75. There is a proposal from the NEC to the government of India.
Hmm.
NEC is also central government, and
Oh, NHEDCL is not central government. It is an autonomous body.
Yes.
autonomous body.
yes,
Yes.
Page
Page
number
number,
75,
yes.
the construction of a road from Gumra of Assam to Ladrimbai of Meghalaya via Jalalpur of Assam with
Who
national.
is there for Union of India, please? You are appearing. What is your stand, madam? Which is the agency which is doing the work?
Yes, I have to take instruction or sick. My instruction not received. Actually, I am applying for 1 and 3.
Hmm. So Union of India, you are there. You let us know which is the agency involved in doing the work.
By doing this BIL, this prayer is for alternative road. First and foremost. That is-
Alternative road.
Yes,
Yes.
Lord, it is
Demand-
demand for alternative national highway.
Oh,
That is the PIL.
how
Basically,
that can be done?
In between, he brought one order of this honorable court, which is reflected in page of addition there. Why addition is done, in between it has come. But main fear of my learned friend is that there should be alternative road, shorten the distance.
No, read prayer A of yours. Go to the Meghalaya High Court then.
No, my lord.
Prayer A, please. Read.
There can be certain, but it is the government to decide.
It covers both the states, my lord.
Oh, gentlemen, which is the executing agency? If we see your prayer, it is PWD NEC Road Division, State of Meghalaya.
No, and the Assam government PWD is also there, my lord.
What is the stand of PWD Assam? Who is the executing agency? Oh, this PIL is not a new one. It's 22. Land Counsel, Mr. Barwa, appearing for the NHIDCL states, makes a statement at bar that the corporation is not the executing agency for the stretch of road in question as referred to in the order dated 8/2/2023. In this way, the matter, we discharge the NHIDCL from the array of respondents. Mr. Nath shall take instructions and apprise the court about the executing agency which is engaged in construction of the road in the Assam section.
As well as, my lord, central government may be directed, my lord, they are important.
Land Counsel for the Union of India shall also apprise the court as to the manner in which the status of the road in question.
Obliged.
List after 6 weeks.
Obliged.
Item number 10.
May I please, Lordship? In this case, your Lordship, the respondent number 10 and 11 and filed the evidence in reply, your Lordship.
Mm.
We want to repeat.
No,
we
filed additional affidavit showing there is a suit pending before the court
So,
below on the
your Lordship, we want to file reply on the,
What reply will you file? Suit is pending, that's a fact.
your Lordship.
If there is a suit pending on the subject matter of this writ appeal, property which is subject matter, then how the writ appeal is maintainable? How writ proceedings are maintainable?
Actually, Lordship, Mr. M.S. Lordship is about to come, your Lordship, he suddenly got illness, your Lordship.
It is stated that lead counsel, Mr.
M.S. Lordship, your Lordship.
M.H. Laskar is not well. Prayer is made to adjourn the matter. Affidavit has been, affidavit has been filed on behalf of the respondents numbers 10 and 11. Wherein, copies of the civil suit pertaining to the same dispute which is raised in this writ appeal has been annexed. It is stated that by Mr. So-and-so that arguing counsel, Mr. Laskar, is not well. List after 6 weeks.
Not so well.
Item number 11.
Pleadings has been exchanged in this contempt petition. What it appears, my lord, in terms of the direction of this honorable court, except showing the interdepartmental correspondence, nothing has come on record to show that.
There was some impleadment application required to be filed. You've done that?
In this case.
Yes. New incumbent. That is already done.
Neeraj Verma has taken over. Lord.
Who?
Neeraj Verma.
Neeraj Verma, respond number 1.
Ready. Is there?
He was already there, but he was removed again.
The same person has again
Same
come
person
back.
has come back.
Again, he has come back. Diganta Burman.
Lordship.
No, Neeraj Verma. Neeraj Verma is.
Diganta Bora is no longer there, Lordship.
He is not the commissioner of police now.
Now he is not.
Okay.
He is commissioner of police, Lordship, but not the commissioner of the department, Lordship.
Commissioner of the department. Okay. So now it is again Neeraj Verma
Again,
and you represent him.
Lordship, not now, Lordship. I haven't filed my power, Lordship. Okalat now.
Then who would be representing?
Lordship, I will have to inform him, Lordship.
Okay.
Recently.
It is
yes.
stated that erstwhile office of Mr. Neeraj Verma, who was earlier holding the post of Commissioner and Secretary to the Government of Assam Home Department, has again joined on the same post. Mr. Bhagwati submit that he
Lordship,
would require.
Lordship, another thing I want to point out, Lordship, their representations were taken care of,
They
Lordship.
have been decided. That was the only direction.
That
Mr.
was
Kamar.
the only direction, Lordship.
My lord,
Lordship, in fact, they had received it in September 2022, Lordship, but maybe, Lordship, that his clients have not informed him, Lordship.
my lord, my learned friend has just given me a copy of this.
Yes,
I
I
will get it verified. Your lordship will get.
What is to be verified? These are official communications.
Well, I have just received it. Well, I don't know because I have so far in the.
Well,
in the
Mr. Bhagwati has
affidavit, it was
placed
not
on record
disclosed.
copies of the communications dated 27/9/22, 13/9/22 and 27/9/22, and urges that compliance in terms of the order dated so and so has been made by these two orders. Mr. Kamar plays for short opportunity to complete his instructions. Monday लगा दीजिए. 12th.
Much obliged.
ऊपर का लाइन भी लिख लेना. He has again taken charge of.
Item number 12.
Right. In this case, my lord, by order dated 6/12, my lord, directed the respondent to pay the compensation as per the prevailing notification, my lord. And the prevailing notification, my lord, 15/11/2014, my lord. Whereby the petitioner is entitled an amount of rupees 5 lakhs. But in the last occasion, my lord, the government has submitted that, my lord, on only 3 lakhs has been sanctioned, my lord. Accordingly, my lord, I have submitted the affidavit, my lord, objection affidavit, my lord. On 7/6, my lord.
Ms. Bhagwati,
Lordship, it is to be dealt with by the revenue department also.
yes, madam.
Lordship,
Hmm.
as regard to the clarification regarding the prevailing notification, the Lordship may kindly peruse the flag mark page, your Lordship. So this is a notification dated 22nd of June 2004, which is still prevalent, your Lordship.
4 or 9. This seems to be 27th August 2009. Flag is 27th
Yes,
August
yes, your Lordship.
2009.
Yes, your Lordship.
Yes.
This particular notification is still prevalent, your Lordship.
What do
So
you
the
say,
payment
gentlemen?
has been made
My lord,
according to this
come to page
notification, your
21
Lordship.
of the orders, my lord. My lord, here regarding the same prevailing as on date, my lord.
Hmm.
And the as on.
As on
my
date
lord,
would mean when the
Yes, my lord.
incident occurred.
Yes. my
Not
lord.
as on date means not today.
Yes. my lord.
Lordship, this
The
particular,
act- And the
When did this incident happen?
this person made
incident
it in
has
receiving
happened, my lord, in
2011, your
the.
Lordship.
11. So in 11, whatever was prevailing,
Yes, your
Yes.
Lordship.
that would be applicable.
My lord,
Okay.
but here clearly stated, my lord, as on date, my lord.
As on date means date would relate back to the date of incident.
Yes.
Okay. Heard and counsel for the parties. There is a material record. The petitioner has been paid compensation in terms of the notification dated compensation for the missing of next of kin within bracket son in terms of the notification OM dated 27th August 2009, which was prevailing on the date, comma, the petitioner's son disappeared. That is, what is the date of disappearance?
1/11.
1/11.
1/11.
1/12/2011.
1/12/2011. Thus, comma, it is clear that the respondents have complied with the order under contempt. Hence, the contempt case is disposed of. Rule is discharged.
I'm deeply obliged.
Obliged.
Item number 13.
We filed an IAM, that they are defaulter, but they filed a reply now. They paid the amount. So I
So-
think my IA will become infructuous.
Ms. Das, submits that in view of the governments made in the affidavit filed on behalf of the respondents that the due amount of settlement has been paid, the interlocutory application has become infructuous. Thus, the same is disposed of as infructuous.
The main case can be taken up after minor vacation.
Already there is an order in that.
Yes, after vacation.
The writ appeal shall be listed for hearing after summer vacation.
Can it be given a date, man? If it is not inconvenient for the.
Let it come up. These are luxury litigations.
Deeply obliged.
Item number 15 and 45.
May I pray for taking the 45 item fast?
As you feel, sir.
Yes, sir.
Yes.
The issue is here, my lord. The right of the contractual employees, my lord. The right before termination, the natural principle natural justice, my lord, whether they are entitled or not, my lord. So, my lord, the impugned order of the land single judge, page number 57. My lord.
57.
57, my lord.
Yes.
And
What was the term of your engagement?
My lord, the initial engagement, my lord, was mentioned, my lord. Page number 47, my lord.
27.
My lord, page number 46.
46.
Initial was, my lord,
There is a
for
contract
for 1.5 months, my lord, but subsequently, time to time, it is extended.
extended.
So,
So
last-
is there an absolute right of extension? So forget about termination. We are asking you, is there an inherent right of extension of contract? Read the original contract. That once the contract is executed, you will have a right to have it continued indefinitely.
My lord, it is, I have annexed, my lord, page number, contract, page number
28.
25, my lord.
28 terms of contractual employment type copy.
Yes.
That is it.
20 sub, yes.
All right. Read in that contract any condition which can indicate that the right to continue on contract is indefinite. And that the employer is under an obligation to keep on renewing the contract over and over again.
No such.
So then
clause.
where is the question of termination? It's a question of non-renewal of contract.
That is my lord.
Then where is your right?
My lord, since my lord, stigmatic order is passed, my lord, the order, my lord.
Which is the order? Let us see.
My lord, page number 48.
48. So we'll clarify that this order will not constitute a stigma and it will not come in your way if you want to apply in some regular process of selection. We can clarify that.
My lord, may I read the impugned order?
Yeah, we have read it. Terminated from contractual because of freezing of bills.
Serious anomaly is there, my lord.
Yes.
So, my lord, if this order is, my lord, stigmatic, my lord, then, my lord,
Let us see your terms of contract. What is the power of removal?
yes,
Read. Or termination of contract.
my lord, clause 2 is the duration of contract, my lord.
Yes.
Page number 20.
So duration, you are not able to dispute that it was 4.5 months.
Yes, my lord. My lord, clause 13, tenure completion,
Yes.
page number 31. Upon completion of tenure or otherwise, the contractual staff undertakes to hand over all articles, books of accounts, documents, etc., entrusted or may have come into his or during the period of contract to
Read para 10, para 11.
11. No claim of regularization in the agency of gov job. The contractual staff shall have no right to claim or preference.
No, 11. Termination of
Yes,
contract.
termination contract. The agency reserves the right to terminate the contractual agreement at any point of time if it is found that the services rendered by the contractual staff is not satisfactory, or if it is found that the declaration of information furnished by him or her are proved to be false or willfully suppressed,
or if there is any breach of any of the terms or condition of this term of contractual engagement, or if the contractual staff is found to be involved in any of the indiscipline or misconduct, or if the contractual staff is found to be involved in any act that may become embarrassing for the agency, or if the contractual staff is absent from job for 1 week without any prior written sanction, in case funds are not available under administrative contingency head from where the remuneration are paid, the contract may be terminated forthwith without any notice. The decision of the agency in this regard shall be final and binding on the contractual staff and shall not be subject to challenge.
So writ has been basically dismissed because there was no continuance of your engagement.
Yes, my lord. But my lord, at the time of discharging or removing, my lord, the word may use, my lord, he was
So we can at best observe that this order shall not be treated to be stigmatic or adverse to you in any future endeavor to get a job.
My lord, this honorable court, my lord, in similar situations, my lord, in similar orders, my lord, have interfered with my.
What will be the consequence?
My consequence, my lord,
Your contract, we can't direct them to continue the contract. No? Is it possible?
My lord, this honorable court's order, my recently on 1/6 also, my lord, this month, my lord, an order is passed, my lord, may I submit, my lord.
Let's see the order.
Copy.
Yes.
The employees of the
Yes. Yes.
I have submitted the 3 of the decisions, my lord. One recent one is Ali Ahmad Barboya, my lord. On 1/6, this honorable court, my lord, passed, my lord. Page number 3, my lord, fourth paragraph, may I read, my lord.
What do you say?
Your lordship.
Your clause 11 gives you the right to terminate services without notice. Only the event the fund is not available. For the other eventualities, the clause 11 is silent. So principles of natural justice had to be followed because the termination was stigmatic.
Your lordship, your lordship, in the review petition, the learned the single judge, your lordship,
Yes.
clarified that the termination order is not stigmatic. Because the termination order, your lordship, can we see,
Yes.
doesn't attribute any misconduct on the part of the petitioner.
It was
And no allegations against him.
allegation. The order reads. Allegations are there in the order. Read the order itself. Why do you want to go to the review order?
Your lordship, here, your lordship, there is no direct attribution. So your lordship may clarify it that this is not a.
No, why?
Order.
You clarify it. Why should we clarify it?
Your lordship,
Where is the order? Where is the order?
My page 48, my lord.
48. Why should you ask us to clarify? Your officers have committed the blunder. Serious anomaly noticed in MIS, so and so.
And the petitioner's duty, he was a computer assistant, my lord.
Hmm.
He was, my lord, regarding this.
Okay, so this termination is because there was some anomaly noticed in the execution of the scheme. This has nothing to do with you, sir. They've frozen all the bills. So the second part regarding there being no funds, that would come into picture. These acts are not attributed to you. Read the order carefully.
In view of the serious anomaly.
In MIS,
In the MIS.
yes. So you are not responsible for that.
MIS, my lord, is the, my lord, data, my lord. It is the duty of the petitioner. He is a computer assistant. He enters the data, my lord, in the, of the MG and REGA, my lord.
Go,
It is
go,
contribute
proceed further.
Regarding.
And
liability of
in the basis
material
of-
components.
yes.
So, my lord, the vendor supply the materials of the works, my lord, like cements, my lord, rods, or my lord, bricks. So these materials bills are, my lord, these computer assistants entered, my lord, in the computer, my lord, MIS, my lord. So it is his duty, my lord.
MIS is the duty of the
Computer
assistant.
assistant, my lord.
So order is stigmatic on the face of it.
Your lordship, your lordship, this contract period was for 5 months, your lordship.
All right, you kept on extending it.
No, your
When
lordship,
did you terminate it?
your lordship, the,
What was, when did the contract
Your lordship.
commence?
14.6, my lord,
it's a.
and the last, my lord,
No, commencement. What is the date of commencement?
my lord,
Your
page
contract.
number, my lord, page number 28, my lord. On 2nd April 17.
So you terminated it, the services within 2 months.
Yes, my lord.
Yes, sir.
April
Your
and
lordship.
June, my lord.
This is not extension, but it is a fresh contract was executed, your lordship.
Oh, gentlemen, you
Yes.
may have executed
Your
a
lordship.
number of fresh.
Yes.
Since when he was initially engaged, what was the date of initial engagement?
Your lordship, the initial contract was signed in the year 2012, your lordship.
Okay, so he continued for 5 years.
And in the last contract was executed in the year 2007 in the month of April, your lordship. Your lordship, the kindly see, your lordship, during pendency of this proceeding, your lordship, writ petition, their term has been overtaken by time, your lordship. It is ended. There was no interim order.
You could have waited for the term to come to an end, and then you could have said. Then there is another issue. You can't replace one set of contractual employees by another. Have you engaged another man or not?
Their instruction is not with me, your lordship.
Okay.
Their instruction is not with me. But
That he will have to plead actually.
Your lordship, the.
Where is the term? Where is this term? Where is the last contract?
My lord, page number 28, my lord. No
We will
term is-
clarify, gentlemen. We'll
no term is
clarify.
mentioned. No term is mentioned, my lord, page number 28.
Your lordship, he has not annexed there as an important document, your lordship.
Which one?
There in the review petition.
Your lordship, he failed to
Annex.
annex the order for contractual engagement,
Where is that?
where your lordship term period is mentioned, your lordship.
You are having it.
Your lordship, yes, your lordship, kindly see the page number 33.
So 33, who has annexed that?
He has annexed it. He has annexed it.
Yes,
Your lordship, the clause 2, your lordship, duration of contract, your lordship.
yes.
The engagement shall be purely on contract basis for a period as mentioned in the order for contractual engagement. In the earlier, your lordship, in his initial.
That is
engagement-
initial, that is, there is no other order. Initial order was 2012. Then you kept on renewing the contract.
Your lordship, we are on the contractual agreement also signed in the year 2017. We are not on 2012 year also.
So what is the tenure in this contractual agreement?
Your lordship, in the review petition, it is reflected that this is for 5 months, your lordship.
Where from this comes figure?
Yes,
Where from this figure comes?
your lordship, he had produced this document in the.
Is it mentioned in this document that it is for 5 months?
Your lordship, this is pardon on him to annex it. It
This
is
is your
separate on
document. Where is the tenure mentioned in this?
Your lordship, that is with him, your lordship. Let him produce it.
He has produced whatever was signed between you and him. You are trying to controvert that there is something else which says that is only for 5 months. Where is that document? You are the employer. You must be having it.
Okay, then your lordship, the fixed another date, I will produce that document from the official record, your lordship.
We are recording your
Since
statement.
he is asserting his right, he will have to produce his document, your lordship.
He has produced a document
No,
which
your
doesn't
lordship,
say
half
any
of the
tenure.
documents, your lordship. Kindly see half of the documents. I will produce, your lordship. I'll produce. it.
You have argued before in the review. 5 months period, where did it come from?
A loose copy was submitted by the petitioner, then, your lordship.
My lord, page 33, it is 2417, my lord.
Yes.
If it is from 2417, my lord,
No.
for 5 months, then it is all.
Where is the 5 months mentioned?
Not mentioned, my lord. How they could get, my lord, I do not know, my lord. On 2417, my lord, it is start, and within two months, my lord, June, my lord, 14th of June, my lord, terminated, my lord. So if it is, for the sake of argument, if it is 5 months taken, my lord, then within 5 months terminated, my lord. On June, my lord, April it is renewed, and June terminated, my lord. Page number 48, my lord, 14/6/17.
Yes.
2nd April.
This
my lord,
is exploitation of contractual labor. Plain and simple by the state. Your order doesn't speak what is the tenure. He is working since 2012.
Kindly see the language, your lordship. Kindly see, your lordship.
Yes, read.
Duration of contract, your lordship.
Hmm.
Where we will get the duration of contract?
You tell us.
Your lordship. Kindly see here the language, your lordship. The engagement shall be purely on contract basis for the period as mentioned in the order for contractual engagement.
All right, then we need
So,
not
your
go any further. Read the clause completely. Your order is illegal simply by reading this clause. You say that it is 5 months. The order says termination without notice will be only in the event of expiry of contract. The
Yes.
contract had not expired 5 months,
Yes,
so the termination could not
Yes.
have been done
There is no
without
dispute.
notice. Order
is
is quashed then. All right,
there is no dispute, your lordship.
then all right.
During the existence of the contract, he was terminated. Yes,
So any notice given?
without notice, your lordship. From the record, from the documents he has produced.
Counsel, why you are showing so much of adamantcy? Produce the record. You are saying 5 months.
In the next day, your lordship will produce.
And counsel for respondent shall keep the original contract signed with the petitioner available. Signed between the employer and the appellant in the year 2017 available for the court's perusal. List on 16th.
oblige.
This is item number.
Oblige, your lordship.
In both the cases, my lord, same order, oblige.
Same order.
Your lordship, may one prayer, your lordship. So far as the item number 15 is concerned, your lordship. Kindly see very basis of his claim is not there. That is absent, your lordship. There is no engagement.
My lord, may I submit? My lord?
There is no termination order, your lordship. Kindly see.
My lord, the writ petition was filed, my lord. Writ petition was filed by my lord, 6 of the, my lord, 6, my lord, page number 36, 6 of the petitioners, my lord.
Hmm.
And petitioner here in the appellant is one of them, my lord.
Hmm. Yes,
Yes, my lord, for a moment, please.
there is no termination at all.
My lord, may I submit, my lord? Page number 19, my lord, the writ petition, my lord.
Hmm.
Petitioner is, my lord, serial number 5.
Yes.
Ramchandra Pal. 6 petitioners have, my lord, filed the writ petition, my lord. And my lord, the earlier engaged counsel, my lord, he had submitted the documents of 3 petitioners, my lord. Since the, my lord, engagement order, termination order, all are of the same order, passed individually, my lord. Same order, my lord. Your lordship will, if compared with the others, my lord. So he preferred to submit, my lord, only 3 of the engagement order and.
In an event, his termination is there on that page 37. Read page 37.
My lord,
What are
same,
you
my lord,
arguing?
was individually, my lord, passed.
He is Ram Prasad Roy.
No, your lordship.
No,
No.
he is Ramchandra Pal, my lord.
Ramchandra Pal.
He is, my lord, documents not, my lord, by the earlier council, not annexed.
So you could have done it in writ appeal, na?
My lord, in.
You could have filed it in writ appeal by seeking leave.
Yes, my lord. My lord.
Then
In this case, my lord, I will file an additional affidavit, my lord,
do that.
on the next day.
Your lordship,
Oblige.
along with the termination order, your lordship, because your contract is also not there, your lordship.
16th.
I will submit. Oblige.
Oblige, your lordship.
Item number 16.
These are drop teacher admission notice list before the special bench constituted to hear matters relating to provincialization.
Highly obliged.
Item number 18.
May I please?
Yes.
But in this case, my lord, we have challenged two things, my lord. One, the rule 13 of the Assam Civil Service Conduct Rule 1965 and the issue and circular dated 2/2023, annexure 8, my lord. What happened, my lord, as per in the year 1965, the scheme of education was not like today's, my lord. Earlier, there was no distance mode of study system. Therefore, during that time, my lord, the condition in the service was that no employee working in the regular mode should not be allowed to pursue the higher education in the without the permission of the authority. But in the year 1985, the IGNOU Act has come introduced by the central government, and in the year 2005, the Hendick University Act has also come into existence. These provisions, my lord, these acts contain the provisions, my lord, which provide that those who are working, they should be given opportunity to advance their career in the and the education should reach to them. This is the scheme, my lord. Scheme of the acts. The earlier position has been changed, totally changed. And as a result, the employees serving in those are teachers, they are, my lord, pursuing the higher education. And the government has also department instructions that you pursue on ODL mode the higher education for the betterment of the self and as for the society and for the students also. As a result, the petitioners as well as other huge number of teachers, they have pursued MA degree, BEd degree and for their own, they have done it, my lord. And while filling up the admission form, there is a column in the admission form itself of the university that you take NOC from your DDO. And they have also done it, my lord. And most of them do not keep the application form with them, but they've submitted the application, they passed the examination, everything done. Now what happened, my lord, all of a sudden they have introduced the impugn office memorandum, whereby they have brought in condition, clause 12, page number 58, clause 12. This is the format given. What happened? What given, my lord? They have given, have you taken NOC for pursuing the higher education, master degree, as well as in column 16 for BEd degree? Have you taken NOC?
Yes.
They have introduced. And your lordship will find at page number 61, last page, this is the form, one example I have given. This is the form of the IGNOU, where there is last column, the certificates are given by the.
What are you aggrieved of?
I am agreed by the condition, my lord.
So how it is a statutory provision?
This is
an office memorandum.
Office memorandum pursuant to the existence of this impugn provision of the 1965.
Which provision? Which provision?
Read the provision.
Where is the provision?
Provision in the Assam Service Manual, my lord. Page.
Page.
Assam Civil Service Conduct Rule 1965, Rule 13.
Page.
Book may not.
What is the page?
Page number in this book 95, my lord. But this new book, it may not.
Assam
Civil Services Conduct Rule 1965.
Yes.
No government servant, while in government service, shall join or attend any educational institution for the purpose of preparing himself for or shall appear at an examination of a recognized board.
Which rule, which clause you are?
Rule 13, my lord. Rule 13.
Yes.
1965 conduct. Rule 13, my lord.
Yes.
No government servant, while in government service, shall join or attend any educational.
So without obtaining previous permission.
Yes.
What is wrong in it?
Wrong, my lord. In this case, my lord, this is with respect to regular mode of.
So whatever the higher education you want to undertake, take permission from your authority.
Yes, they have taken permission.
Then what is wrong? What is the problem?
But they are seeking, instead of taking from the appointing authority, it was given by the DDO, but they are not accepting the DDO.
Yes, obviously. So rule says the DDO is no one to give you the permission, but has to come from the appointing authority.
But there was no such specific circular in the.
Circular means
but
what?
they have allowed, my lord, your lordship will find.
The rule reads, so there is no need of circular. Rule is clear.
But since 1997, since the provincialization till 2022, my lord, all the teachers, those who have passed the MA degree, they have been allowed to.
That one illegality cannot be allowed to perpetuate.
This is not illegality, my lord, at all.
Yes.
This is irregularity might be. This is not illegality. For that, my BEd degree, my MA degree cannot be said to be illegal, invalid.
You have not challenged the rule.
Have
You have
challenged
challenged the rule.
here.
Read. Where is the challenge to rule?
Yes, sir.
All right. Issue notice. File your affidavit.
Oblige.
All the respondents are duly represented.
Yes.
Sufficient copies of writ petitions. Writ petition be provided to when it's standing counsel appearing for the respondents who pray for and are granted 6 weeks time to file affidavit on behalf of such respondents.
In the meantime, my lord, the clause 12 may be suspended for time being.
Sorry. Prayer for interim relief refused. Want us to do that right now? No.
Oblige, Lordship.
Item 19.
May I please, Lord?
Yes.
It's an appeal under section 260 of Income Tax Act, my lord. It's the order passed by the learned tribunal, my lord. My lord, in this case, lordship, what has happened, my lord, the assessee, my lord, which is in the refinery, my lord, Moligo refinery, they have expanded their unit substantially in the year 2000.
Someone appearing for this, you are appearing?
Lordship.
Yes.
Lordship, they have, my lord, make a substantial expansion and they manufactured a new product from 2006 that is called, my lord, motor spirit oil, lordship. That is commonly known as the, my lord, gasoline. My lord, for the extended the expansion unit, lordship, they have claimed exemption, lordship, under section 81B, subsection 9, my lord, which says, my lord, the exemption, 100% exemption will be granted, my lord, on, my lord, refining of mineral oil. Now, my lord, their contention is that, my lord, the process of manufacturing, it is a refining of mineral oil, lordship. And for the purpose of Income Tax Act, lordship, section 81B, subsection 9, my lord, it has a restrictive meaning of refining only, my lord, not including the manufacture and process, lordship. So, my lord, based on their submission, my lord, the learned lordship, the tribunal, they have interpreted section 81B, subsection 9(3), my lord, to include, my lord, the petroleum products in the meaning of mineral oil, lordship. So, my lord, we have raised,
where is your question of law to this effect?
lordship.
Read page 14. There is no pertinent question of law what you are arguing.
Lordship, in fact, lordship, we have lordship proposed a new question of law, lordship.
Let's see. Because your question of law is mentioned in para 6 of the appeal.
Lordship.
They don't seem to be questions of law.
Lordship.
They're basically questions of fact. What do you say? We'll admit the appeals.
Yes. Yes.
The appeal,
And there are other connected appeals also, so that.
the appeals are admitted on the substantial question of law in the following terms.
Lordship, lordship, may submit, lordship, one more question of law may be formulated, lordship. Whether on the facts and circumstances of the case, learned tribunal was justified in, my lord, deleting the additions made by the assessing officer. That too may be sufficient, lord.
Is there in your pleadings?
Lordship.
Read page 14.
Lord.
Which of these questions?
My lord, this all four, my lord, that will be included, my lord, if your lordship put a substantial question of law as to whether on the facts and circumstances of the case, the learned tribunal was justified in, my lord, deleting the.
So that is question number 1, page 14.
Lordship.
Read.
Lordship, whether on the facts and circumstances of the case, the tribunal was justified in law in deleting the addition made on disallowances of the claim of deduction under section 81B(9) of the Income Tax Act for the motor spirit new industrial undertaking of the assessing company commission on so and so.
This is what you want to be added.
Lordship, that will be included, lordship, because other provisions are also there, lordship.
So, all right, then you precisely formulate a question, then provide it to us.
Lordship.
We'll incorporate
Lordship,
on the following substantial questions of law. You give a fresh one, fresh
Lordship,
sheet.
Lordship,
Then on purpose.
deeply obliged.
Connect with so and so. There is, Mr. So, your good name, please.
J.
J. Roy appears for the respondents.
Respondent,
Respondent, sole respondent.
sole respondent.
Copy of the appeal be provided to him. What is the IEA? In
Lordship, this is a common order for 7 assessment year.
No, no, what is the IEA about?
IA is for dispensing with the filing of the original certified copy law.
Interlocutory application filed by in so and so for dispensing with the requirement of filing the certified copy is allowed.
Deeply,
Of the judgment passed by the ITT is allowed.
deeply.
Connect with so and so.
27,
Number, which other appeals are there?
20, madam. Yeah,
No, these are two. You said there are few more.
there are other first.
Give the numbers, please.
Lordship,
I'll
in
give it.
other appeals, Lordship, delay has not been condoned and
Okay, then let them come.
Lordship,
Yes.
Lordship.
Okay.
I'll furnish a fresh copy.
Yeah, you give the
Lordship.
proposed questions.
Lordship.
Both are yes.
Item 21.
Dearly Lordship.
Yes.
The other day, as per your Lordship's order, we have filed an additional affidavit. I have made a gist of the events. Lordship may kindly see. Here Lordship would say the writ appeal number 143, your Lordship passed order, that is 173 of the additional affidavit. Now, in this case, my lord, on 31, kindly say para 2. On 31/3/21, the learned single judge passed order in our favor. That there is dispute in this case, which one is the real school? And perusing the document, the order of provincialization of the private respondents were kept in abeyance. Then, my lord, they filed in IA to vacate the said order. In that order, only they used one dice code packet.
One?
Dice code. Dice code, that's what district level code is there,
Okay.
given to all institutions. And in dice code, my lord, that dice code, Lordship may kindly see page 181 to 191. This is important, Lordship may kindly see 181.
Hmm. 181 is your
181
IA.
is dice code, my lord. 181. They have relied on this dice code, but Lordship would see here this
181 is your interlocutory application, sir.
that is petition starts, but dice code Lordship may kindly say page 194. 194. Here Lordship would not see the name of the private respondents.
Hmm.
They have only on the basis of this dice code that is as incorporated in section 2 within bracket S
Hmm.
of the 2008 dice code is given. Now they have annexed this dice code, but here is no name of the private respondent, that is Tanmia. His name is not here. But
Yes.
in my dice code, my lord, for a moment I invite to my lords kindly go to page 116 of the writ appeal.
Hmm.
116.
All right, we'll issue notice to the respondents. Third, issue notice to the respondents. MS Arbora appears for respondent number 3. You appear for, sir?
I appear for the elementary education.
For
Standing council elementary education.
Standing Council Elementary Education. The respondent number 1 and 2.
1 and 2.
And 4 also. 1, 2, 4,
5.
5.
5.
Thus, on steps for service upon the remaining respondents be taken in 7 days whereafter process the issue.
Appeal is maybe kindly admitted, we have sufficient proof.
First, get them served. This is against an interim order. We'll
No,
decide
final
it.
Final order. Against the final order, that is also my question. On that, the IA was fixed.
Okay.
For consideration.
Admit issue notice.
Item number 22.
Yes, please.
Please, Your Lordship. But this case is relating to regularization of service, Your Lordship. Your Lordship will kindly see impugn order page 78, Your Lordship. The regulation of service of the petitioner. Petitioner rendering services about 37 years under the authority, Your Lordship. Till then, his services was not regularized. When there are several correspondences, Your Lordship, by the authority itself or the appellant itself, Your Lordship. There are various communication, Your Lordship. Your Lordship file one of the communication annexer.
Read para 18, sir.
Annexer.
Para 18 of the order. Read para 18
Para 18.
of the impugned order.
As such, even if it is assumed that person has rendered a long period of services by way of such appointment issued by the managing committee of the school in violation of the statutory recruitment rules in force, his or services cannot be regularized since the incumbent appointed in such manner does not have any legal right for regularization. But the school where he is working, Your Lordship, thereafter the high school also there. Subsequently, the high school was the school was amalgamated with the high school, Your Lordship. But that's the school was provincialized after the appointment of the appellant, Your Lordship.
So why didn't you come for provincialization of your services for all this period? Tell us.
As the petitioner rendered 37 years,
Understand, sir, the school was provincialized. At that time, if you were working, your services would have been provincialized.
My lord.
There was no requirement of regularization then.
But unfortunately, his post was dropped, Your Lordship.
So the issue had to be raised then, sir.
My lord.
That was the dispute. It should have been raised at that point of time.
Posts are available. One post is vacant, Your Lordship. But the authority itself right proceed.
But we are asking you that when the school you are working in was provincialized, all teachers working therein, their services would have been provincialized. Why you were left out?
This is the fault of the respondent, Your Lordship.
So then what you were doing? Were you sleeping?
Your Lordship will see my paragraph 11, Your Lordship. Paragraph 11, Your Lordship. May I read it? That the headmaster of the Government High School had issued a letter dated so and so to the inspector of school, Baksa District Circle, Musalpur, to appoint regularization service of the petitioner Mohammad Tamizuddin Ahmed working.
Mr. Chaudhary, we are asking you, when was the school in which your client was working provincialized? Which year?
He was appointed in the year 1986, your lordship.
Mr. Chaudhary, when was this school provincialized?
School provincialized, your lordship will 77, I think. That school. But the high school subsequently, when the petitioner was appointed, high school is subsequently, that is in the year 2017.
2007. At that time,
17, my lord.
17. At that time, why didn't you raise an issue that my services should also be provincialized, since the school has now been provincialized? For all these years, what you were doing? You say that you are an honorary teacher, meaning that you are serving without a single penny,
My lord.
without any remuneration
My lord.
or honorarium.
My lord.
What kind of service is that?
The authority has also submitted various correspondences, your lordship, to the respondent, your lordship, to regularize the services, as I have, your lordship will, I have already stated, Annexure 11, your lordship. Annexure 11, your lordship will permit. Page
Your appointment was totally illegal, sir. What is an
Page
honorary teacher
page
post?
46, your lordship.
What is?
Page 46.
Madam Bola,
May I-
will admit the appeal.
No, Lordship, because Nana Singh is rightly.
Or we are just admitting the appeal. We'll hear it at leisure. What else? Admit.
Lordship,
Master.
Lordship, already reflected in the judgment, the school was provincialized in the year 1977. He was appointed by the managing committee after.
Could not have been done. Could not have been
Yes,
done.
Lordship.
We'll
And
consider it.
speaking order has been passed by.
We are just admitting the appeal. We'll hear it when the time comes.
Master.
Okay.
Item number 23.
Case, I have no instructions from the respondent number one, my lord. I have no instructions from the respondent number one. I wish to serve a letter of withdrawal to the respondent number one.
What is the matter about?
That was your lordship's order dated 8/5/2023. There was a scrutiny committee which your lordships had directed. There was a report submitted. I've communicated, my lord, but there's absolutely no.
My lord, the issue was whether what is the date of my appointment? Now, the committee has revealed that it is 2nd of August 2006.
Okay.
So therefore, my lord, that was the only bone of contention.
Okay.
Consequently, my services has been provincialized.
In terms of this report,
No,
or
before
earlier?
that, no, lordship directed that.
Only this is a confirmatory kind of action. All right, then we'll admit the appeal, issue notice to the respondent. You plead no instructions. Mr. Ganguly, who was earlier engaged for the respondent number one, pleads no instructions. The report of inquiry, copy of the report of inquiry placed on record by the Standing Counsel Education Department shall be retained on the record, and the original shall be returned to Mr. Katniar. This is a photocopy only. Well, a copy of the report shall be retained on record, kept on record. The appeal is admitted. Admission notice. Steps for service on the respondent number one be taken within 7 days, whereupon process be issued to such respondent. The other respondents are duly represented. Thus, process need not be issued. Please for hearing in due course.
The interim order will continue.
The interim order dated so and so is confirmed to last till disposal of the appeal. Please for hearing in due course.
Item number 24.
May please, your lordship. My lord, in this case, my lord, the petitioners are seeking approval to the two schemes for protection against devastating erosion in the southeast of Bopata district, my lord. My lord, approval is
Protection against?
against, my lord, erosion, my lord,
of Brahmaputra.
Erosion.
Yes, my lord.
Okay.
My lord, here, my lord, the earlier, the Brahmaputra board has required, my lord, modified DPR, modified project report that was submitted. Therefore, they asked for mathematical model study report. That was also submitted by the government, my lord, Assam government, Water Resource Department, to the IIT Guwahati. So, my lord, now, my lord, approval is required, my lord, that should be, they may be directed to grant approval to the scheme, my lord.
What do you say?
Yes, my lord, the requirement that have been fulfilled by the state government authorities under the state government. So now matter is in the court of my lord, water commission, Central Water Commission.
Central Water Council.
Commission.
Commission.
What we need to do, my lord, on the part of the state government that have been fulfilled.
You have recommended already.
Yes.
Where is your recommendation?
My lord, last one, as your lordship will, my lord, as per the last affidavit, my lord, we have annexed the mathematical study report, my lord.
There's a DPR also.
Yes.
Okay.
Everything, my lord, after.
Where has it been forwarded? Let us read. It's an
my lord,
affidavit of your ACS, Additional Chief Secretary.
Yes.
That's right.
Yes, my lord.
Hmm.
Take a last one, yeah.
Page 111.
Last one.
That's the
No, idea report. It was in. My lord, affidavit, last affidavit, that is, my lord.
2020.
Para 9, project was approved by the Administrative Department, Government of Assam Water Resources. Where do you say that it has been sent to the central government?
Yes. But next affidavit, last affidavit, my lord, that was filed on 4/3/2023, my lord. In that affidavit, my lord.
4/3/23.
My lord.
Yes. Okay.
My lord, the report at page 111, my lord. That is,
111.
That is the report, my lord, furnished by the IIT Guwahati, my lord. That is on receipt of this, my lord. This has been submitted to the.
Where is that forwarding submission letter?
Oh, that part, my lord.
You have to place that on record so that we can perhaps issue, direct the central government. And Council, Mr. Kakati submits that pursuant to receiving the report of mathematical model study of Brahmaputra River from Bahari to Bagbar as undertaken by the IIT Guwahati, the state government has forwarded.
That is page 141, my lord. Last one. Submission of final report. What should we look at this?
141.
Yes.
Problem is your pagination is wrong.
Nowadays, we have to start from the name of it.
What is the document you are referring to?
My lord.
What is the document you are referring to? Because pagination is not correct in your affidavit.
That is annexure B. In fact, the last.
Annexure B.
Yes. Last affidavit, my lord. Last affidavit, additional secretary, my lord.
That we have. Which page of annexure B?
My lord, it's a letter dated 30/1/2023 issued by the chief engineer, Water Resource Department, Assam.
So this has been sent to the chief engineer, CWC. Submit that the report, final report.
My lord, point out another aspect, my lord. After this, my lord, after receiving the report, my lord, the Central Water Commission also asked the state government to furnish the modified last as per the report, the last one, that is the modified scheme.
Why don't you place that letter on record?
Yes, that is there.
Give it to us. And Council, Mr. Kakati has drawn the attention of the court to the communication dated 30th January 2023.
And this
issued by the Chief Engineer, Water Resources Department, Guwahati, to the Chief Engineer, Central Water Commission, along with which, the final report for mathematical model study of Brahmaputra River from Bahari to Bagbar for evaluating the proposed scheme under nomenclature R/S to B/Dike from Bahari to Bagbar has been annexed.
Yes, and last
The
one,
Chief Engineer, CWC, a further communication dated 19th March 2023 is placed on record as per which, the DPR has been forwarded
I think it is 17, madam.
19.3, as per which, the DPR along with the estimate for the work has been forwarded
19.
to the 513 crores
Yes, madam. That is why, my lord.
has been forwarded to the Chief Engineer CWC.
Because
Mr.
lines here will come from the Santi Ram.
Mr. RKD Chaudhary, the Deputy SGI, shall take instructions from the concerned authorities and file affidavit on their behalf as to how the project is to be carried forward in view of the above development. Give a copy to Mr. List up 4 weeks, 6 weeks.
Deeply obliged.
Item number 25.
My lord, we on behalf of the intervener number 5678 for the community, Gorkha community have filed the affidavit, my lord. And it is not tagged, yesterday it was filed only.
We received the copy, my lord, yesterday at 3 p.m. Yesterday we received.
It is not tagged in the file.
Affidavit on behalf of newly implemented respondents numbers 5, 6, 7, and 8 has been filed yesterday. The
Yes.
same be brought on record list after summer vacation.
Item number 26.
Petition lordship, on the last occasion, your lordship has given the liberty to file affidavit in opposition in the writ appeal, since the affidavit could not be filed in writ petition order. They have 3 weeks time may be granted, and we are waiting for it.
Louder,
3
little.
weeks time may be granted to file out.
For the time,
We are waiting for the.
counsel for the respondent. ESIC, you appear, Mr. Smith appearing for ESIC, praise for and is granted further opportunity of 4 weeks so as to file 6 weeks to file the affidavit. On behalf of the corporation.
Item number 29 and 30.
This is the appeal by the revenue. There were 2 appeals by the common judgment lordship. I suggested some question of law lordship may for consider.
What do you say, sir? Should we admit the appeals?
In my humble submission, the questions have already been decided. So if you lordship.
Questions are already decided.
The first question was the excise exemption, which you granted, whether it will capital receipt or not. Now that issue has been already been, the judgment of Jammu Kashmir was there. Thereafter, the matter was carried to appeal with Supreme Court. And Supreme Court held by following the earlier judgment that no, this will be capital receipt. Now, second question is saying about the 115 JB, that also with different.
This capital receipt issue, we have also decided your appeals.
No, okay, fine. In this case, they for the all times they saw it to be that judgment is there for the apex court. The bookkeeping entry will not make any difference. The character of the receipt to be seen. During the appeal, they come up with the this plea and without giving any notice that was decided. Lord. Your lordship, you see this.
Appeal was decided without notice.
Yes, no, lordship, no, that plea was taken for the first time. Lordship, then this was decided against the revenue law. So the appeal authority could have been returned back to the ITO for deciding phrase lordship, giving opportunity to that department lordship. So that judgment, you see the Supreme Court as well, division court also. where the subsidy amount was shown under the heading of sale turnover.
Hmm.
And this honorable court said, my lord, that.
Let it lie, sir. We'll see.
Yeah, your lordship, I have no.
The appeals are admitted on the following substantial questions of law. Which particular questions, Mr. Gale?
1, 2.
1, 2.
Not,
1 and 2?
not said that will do.
All right, 1 and 2.
Both the appeals.
The respondent is duly represented and by Dr. Saraf, senior advocate Dr. Saraf. Thus, notice need not be issued.
I'm obliged. Much appreciated.
Item 32.
May it please your lordship, I have filed a reply affidavit today morning. It
Okay.
has just reached my learned senior friend. I pray for a date. After
And
10
Counsel
days.
Ms. Chaudhary submits that she has filed reply affidavit today morning. You had filed one on 2nd June also.
Earlier, again, today again, she
Has filed a fresh affidavit in reply today morning. The same be brought on record. List. No, it goes to July, madam.
Lordship, 19th of this month, if possible. The stalls are closed, lordship. They are in difficulty.
Lordship had passed an order of status quo, lordship. If it was closed, it was closed, lordship.
After that, a lock was put, lordship.
All right, 19th June.
Grateful.
Supplement.
Supplementary list, item number 44.
May I please, your lordship? May I please, your lordship? We have withdrawn the case, lordship.
We have
We have withdrawn the case, lordship.
withdraw.
Yes, lordship.
Counsel for the petitioner craves liberty to withdraw the writ appeal. Hence, the same is disposed of as withdrawn.
I am for the respondent's statement.
Attendance.
Item number 48.
It seems nobody is here for the.
I am praying for some accommodation, my lord, after some time, my lord.
Pastor.
Item number 49.
My lord, before my learned friend starts, item number 49, there's a judgment passed by my very lord. Similar matter. My lord had dismissed the case because the tenderer was 13th in rank and he had taken part in the bidding process.
You are in which item?
49.
49, my lord. The matter
49 has been passed over.
is-
48 tha kya? Acha.
49.
Okay, okay. Just let's see.
This is that matter, my lord, which
Judgment-
your lordship heard yesterday regarding the two conflicting views taken by the honorable single judge with regard to clause 10 of an NIT. I sought time for taking an instruction, my lord, that yes, it is true my lord, that the appellant had participated in the tender process.
Then
No, the-
having
just-
participated thereafter,
No, the repetition.
selling
was-
in condition of the NIT,
Yes.
that's not possible. So you want us to decide the case in that light?
My lord, lordship will pass the order. my lord.
Okay. What judgment are you relying
My
on?
lord, I just shared a copy. Shivram Becca versus State of.
In a connected appeal to the same issues, my lord.
Same issues.
Same.
Oh,
There he was 13th in rank and my learned friend here is.
I learned
6th in
counsel for
rank.
the respondent is drawn the attention of the court to the order passed by this court in the writ appeal number 395 of 2022 pertaining to the very same NIT in question, whereby, the challenge laid by one of the bidders at par with the appellant herein was repelled. to the clause number appellant hearing was for 10 of the NIT, which is the bone of contention in this writ appeal, was repelled. Full stop. It is not in dispute that the appellant herein, comma, participated in the bidding process and was rated much lower in the financial bid evaluation. It is also not in dispute that persons whose financial bids were evaluated much higher than that of the appellants have not been implemented as parties in this writ appeal, as parties in the writ petition, oblique the writ appeal at hand. Thus, comma, we are of the firm view that having participated with open eyes in the NIT in question without challenging the allegedly offending clause number 10 of the tender notice, comma, the appellant cannot be allowed to raise an objection there against after having failed in the bidding process. With that apart, comma, the writ appeal of the similarly placed bidder having failed, comma, there is no reason for this court to take a different view of the matter. Hence, the instant writ appeal also fails and is dismissed as being devoid of merit.
All right.
Item number 50.
Wait, Your Lordship.
Yes.
There is some developments at the
What development?
level of the
What is the development? Let us know.
development is an inquiry has been directed
Against
against the police.
police officials? Who is conducting the inquiry?
My lord, this lordship may kindly have a look at the order. It's an order by the Inspector General Police
Okay.
with reference to the subject cited above. Assam Police Headquarters has taken a note of the media reports and initiated the following actions. An inquiry has been ordered into the whole sequence of events by the police headquarters, and
Yes.
necessary action will be taken against the erring officials on receipt of the
Yes,
inquiry.
yes, sir. Let the inquiry be conducted then.
Well, there is another aspect. I'm just indicating, it gives your lordship a scheme. But the main accused has filed an application for anticipatory bail. Matter came up on 2nd or 3rd. On that day, CD was called for no interim. Now, it was indicated by the petitioner, same counsel is appearing for the petitioner there also.
Counsel appearing is.
I'm not on this, but he has taken time on that day and the case was fixed on the next day for CD.
So
that was, I'm not kindly be with. That was on 7. 7, they have said, let us wait for the outcome of the habeas corpus petition. Madam, habeas corpus petition has got no relation with that.
So you could have insisted before single bench to decide the
We were
fourth
ready
appeal.
with the case diary. I have taken information.
So Mazumdar,
I'm not.
we have seen your affidavit. You want us to comment on that? What? Just hold on. The other day, remember your arguments. Your argument was that the lady was suspected of hiding information about the main accused, right? For what offenses you have arrested her?
No, she was not arrested, my lord. Let me kindly see the document.
Now you have shown her arrested or not? The
Yes.
second wife.
Yes, ma'am.
For what offenses? 120B, 302,
Well, she is
conspirator in the murder.
She is hiding.
Let us see the
evidence. Well,
hiding evidence, that is 211. Okay. Harboring an offender 212. CRPC लीजिए थोड़ा सा हाथ में. Even if what you are arguing is correct, read CRPC please. Schedule. Let the inquiry officer hear our view, which is there on the YouTube now.
201.
Yes, 201. What is the nature of the offense, please?
201. Causing disappearance of evidence.
No, in the column of bailable, non-bailable.
My lord. Bailable, yes.
Bailable.
Bailable.
So just in order to ensure
My lord.
that some of you have taken police custody of the woman in a bailable offense,
He was not taken to.
Mr. Mazumdar, you want us to comment on your investigation right now? You could not have had any evidence to show her as a conspirator at that point of time. Just to somehow or the other justify your action in arresting that woman with a minor child. You have booked her for a conspiracy in murder, when you didn't even have material against the main accused. The first report was silent. Second report, there was a suspicion. And now you pull up a lady for conspiracy in murder when you don't have even evidence against the main accused. What kind of acts are you trying to justify, please? All right, we'll request the Director General of Police to supervise the inquiry.
Conducted,
And if at all there is any kind of humanity still left in the actions, these ladies should be got released. This is inhuman on the face of it.
I'll take care of them. Initial actions, the lordship has on the last day indicated that during the early morning.
Judgment dena sakhe.
I don't support that, of that action.
46-4.
I don't support the action. On that itself, she also said, sorry, my lord. I'm also saying, I'll ask them not to do in future.
Not to do in future. What about what has been done till now?
That's what I'm also saying.
Why not? Why shouldn't we direct that they should be compensated? Read this judgment.
My lordship will hear the matter. I will file a detailed affidavit.
All right, then argue. Let us see the case diary and see whether there is any justification for their arrest.
My lordship will take up the whole matter for some other for final disposal today. My lord.
Habeas corpus.
Habeas corpus. The first part has become redundant now. For the second part, they have the matter is to be heard.
Why redundant? If we find that your officers arrested the ladies without any basis whatsoever, why the first part has become redundant? The scope of habeas corpus is wide enough, Mr. Mazumdar.
46-4 is there.
Call your SP now. We'll ask her. What evidence was there to book this woman for conspiracy? Yes.
They are here.
Yes. Let her come forward.
Yes.
She is a young officer.
My lord. Out of.
Let her say, Madam, be fair and make a statement. What was the evidence with the IO to book this woman for conspiracy of murder? Come forward.
Good morning, Your Lordship. The woman was examined over a period of 5 days. We have recorded her various.
5 days.
We have recorded.
Initial arrest for what offense?
The arrest was carried out on the 31st of May for 120B 302 201 109.
So when she was first picked up, what was the evidence against her?
The day that she was first picked
Brought to the police station at 4:30.
at 5 a.m. Your Lordship.
5 a.m. So in Indian context, that is still night. Right? Assam doesn't have any other time zone as against the time zone of the country.
The first wife who was brought at 5 a.m. She was examined. The initial offense was 212 IPC.
212, yes. Now pause here. When the initial offense was 212, did your IO offer her an opportunity to furnish bail bonds or not?
She was not arrested, Your Lordship. She was, because 212 IPC has an exception for the wife harboring the husband. We issued 160 CRPC and we continue to examine her to elicit further information.
So now we put you a plain and simple question. As an officer of the court, tell us, is there evidence in your case that it would justify 120B? There is. Only let us see then. We'll examine it. If you are still adamant on that, we'll examine it. Yes, Mr. Mazumdar. Get the case diary.
This will give for your lordship perusal. Publicly will not announce it.
Of course.
For your lordship.
No, we'll not make any information public. Rest assured.
Now that there is live streaming also.
Yes, we are sensitive to that. Live streaming one.
Lordships are conscious.
the pendency of these proceedings shall not be an impediment in the consideration of the appellants for promotion. Cannot be said who was the person who had actually filed the WPC. Report is vague. Then we can direct registration of an FIR actually. Impersonation is there apparently. The report is vague. What to do?
Only by humble submission to that extent, Lordship. There
No,
should
we
not be
have
any
taken care of your issues. That was, we can direct registration of. वो आइए में आइए दे दो. As a consequence of the order dated 5/12/2019, the Deputy Registrar Judicial conducted an inquiry wherein, the conclusion, no positive conclusion has been given as to who was the actual, as to whether the writ petition in question was filed by the genuine person named Jaydev Das or the same was filed by an impersonator. It has been indicated that without proper examination by professional experts, it will not be possible to determine if the said signatures were of the same person. In this background, we hereby direct that the copy of this order, the court's order dated 5/12/2019, with a copy of the inquiry report shall be forwarded to the Superintendent of Police concerned for making a preliminary inquiry into the matter. The report of preliminary inquiry shall be placed on record for the court's perusal. 3 months' time is granted to the Superintendent of Police for conducting the said inquiry. Copy of this order shall be transmitted to the DGP Assam for assigning the same to an appropriate officer. IA is disposed of. अरे ये फिर कैसा होगा इसमें? Where is the IA disposed of? This IA is disposed of. हाँ ठीक है, writ appeal में कर दीजिए. Okay, very well. You are appearing for agriculture?
Yes,
Mr. Chaudhary appears for the agriculture department. Is-
I apologize because our name was.
No, your name was not there. G Assam mentioned. Okay. Henceforth, it will be SC agriculture.
Yeah.
Okay.
Highly applied.
Hearing all complete. Okay, pass over matter. 48. What is that?
May I please the Lord.
Mm.
But there is a caveat in this appeal, my lord.
Mm.
My lord, we are the members of the Panchayat, my lord. On 18th of July, my lord, we brought requisition for no confidence motion against the president.
Mm.
And meeting was held, my lord, on 9/8/2022.
Yes.
No confidence was passed. Resolution was adopted.
Mm.
But in the said meeting, my lord, a resolution was passed by raising hand, by
putting signatures,
No secret ballot.
no secret ballot.
Okay, so that was vitiated.
Therefore, my lord, they approached this honorable court. Honorable court, my lord, demanded the matter back. And
That
fixing
was actually, there was no cause for remand. That was a substantial failure.
it.
That was a 6 months time should have been allowed then. Anyhow,
No,
so it was
the
remanded. Then,
honorable court told that, my lord, no confidence is not lost. Therefore, my lord, 6 months will not come, my lord.
okay. It was a case of losing
Lordship.
because it was a substantial failure. Yes, very well. Then what
Then,
happened?
my lord, this honorable court, my lord, fixing, my lord, date 17/9/2022. And my lord, further fresh notice, my lord, requirement of notice, my lord, was, my lord, dispensed with.
Okay.
The Ansulik Panchayat, my lord, thereafter issue a notice, my lord, on 14/9, informing the members that meeting will be held as per honorable court's order on 17/9.
Yes, then what
And
happened?
accordingly, meeting was held, my lord. And in the said meeting, my lord, this time, my lord, voting was taken by secret ballot. And no confidence was passed by 7-3 ratio, my lord.
Yes, then,
And resolution was passed, my lord. Thereafter, my lord, deputy commissioner, my lord, entrusted the vice president, my lord, to look into the matter of the president.
okay.
This time, my lord, second writ petition was filed before this honorable court.
Yes.
My lord, basically 3 ground, my lord, they have taken that the meeting was held by the president. It should be held by the executive officer. Second ground, my lord, was taken, my lord, that's 17(3), my lord, section, my lord, which requires 3 clear days notice was not followed. And third point is, my lord, that 3 members of Ansulik Panchayat, they were also attended the meeting.
Yes.
Learned single judge, my lord.
So there remains no secrecy in the proceedings. If extraneous elements are present, then what is
Now,
the
in this-
secrecy?
In the voting, my lord, the president, my lord, herself remained present. He, my lord, took part all along.
That
my
is all right. That is all right.
lordship.
But why the meeting was convened by the president and not by the as required under the provision? It was to be done by the,
president,
okay, president of the Anchalik Panchayat.
Ansulik Panchayat.
Okay,
The
let's see
meeting-
the findings.
No, now, my lord, learned single judge, my lord, only on the issue, my lord, that 3 members of Ansulik Panchayat remained
Yes,
present.
that why they were inside the
Because, my lord,
meeting.
the Ansulik Panchayat president, my lord, while issue notice to the members. He
The
also-
members of the Gram Panchayat were required to be present,
And he
not
also,
of the Anchalik Panchayat.
he also issued notice to the members of the Ansulik
So
Panchayat.
that vitiated the proceedings.
Yeah.
Where was the requirement? There was a possibility of tempering influence, everything. Outsiders present in the meeting.
Now, my lord, as per, if your lordship consider the notice, my lord, 14/9.
We are asking you whether outsiders could have been present in the meeting.
Lord, in the sense, my lord, outsider, my lord. My lord,
They had nothing to do with the Gram Panchayat. They were only that was an outsourcing to the Anchalik Panchayat. Only the president could have remained present.
now 17/4, my lord, 17/4, my lord,
Yes.
section, my lord, 17/4 of the Panchayat Act, my lord.
Read para 32. The entire scheme of constitution has been considered.
Findings of the learned single judge, my lord.
Yes.
Findings, my lord,
Where
is
fresh special meeting was ordered. What has happened in that?
It is fixed on 12th, my lord.
It is scheduled on 12th.
12th.
So let the meeting take place. What is the urgency?
now, my lord,
Let the fresh meeting take place.
now lordship consider, my lord, the judgment of the Honorable Supreme Court, my lord.
Padmini Singha,
Lordship.
presence of president. The process has not been interfered on the ground that notice was not there to the president.
No,
We
here
have,
also-
we have,
Here also, my lord, the meeting was conducted by the
Anchalik Panchayat,
Lordship.
presence of 3 members.
But here, my lord, the president also took place, my lord, in the meeting, and resolution was passed against her. And
Sir, you are just sidetracking the issue. How do you justify presence of 3 persons who are not concerned with the proceedings?
now, as per section 17(4), my lord. The officers to whom notice is given, my lord, 17(4),
Officers,
officers,
are the members officers?
my lord. The members, my lord, they were given notice, and on bona fide they appeared. They did
There's
not took part in the.
No bona fide, no bona fide. It's all a pre-designed manner to influence the voting, to keep other people present, for influencing the procedure. There is a sanctity to the procedure. It has to be foolproof, watertight compartment. If you allow other people,
Voting was taken.
why you are shying away from the meeting on 12th? Some people have been broken away. Horse trading, good.
Now we are the members, we brought no confidence motion.
Yes. Okay.
So motion was passed.
So we'll rather now we'll in your appeal, we'll observe that the motion has been lost. So do it again after 6 months. You'll be happy by that. Yes, Ms. Das, what do you say?
Well, paragraph 35 and 37,
Hmm.
the Honorable Single Judge has dealt with the matter.
Hmm.
And it is said that paragraph 35 at page.
Yes.
That it is vitiated because of the. Page 69. Paragraph 34, well, page 68.
Yes.
Within this, it is clearly emerged that the vice president and the 2 members of the Anchalik Panchayat, judicial Anchalik Panchayat were unauthorizedly present and took part in the deliberation held forth for the motion of non-corporation. And thereafter, it has learned single judge has come to the finding that there was a pre-vote meeting before the process of voting of the secret ballot. It is common record. They have admitted in their affidavit. But taking note of the fact that the requisition notice is yet there, therefore the learned single judge has called for the new meeting to be held on 12th.
All right. Yes, thank you.
Item number 37.
Yeah.
Wait, your lordship.
Yes.
My lord, may kindly have a look at the last order, 33/22 of this honorable court, my lord.
Lordship, I was given opportunity to take instruction whether the.
Which order, madam?
Lordship order 33/2023 last order.
Yes. Withdrawal.
My lord.
Lordship, I have taken instruction, Lordship, that since the basic prayer of the petition is already served, we may be given liberty to hesitate the rest of the prayer before the responding government, Lordship.
All
By
right,
giving
then
that
Counsel
liberty-
Mr. Das submits that as the primary principal prayer made by the petitioner in this PIL has been ventilated, grievance kar dijiyega, has been ventilated, comma. He may be allowed to withdraw the instant writ petition, leaving the petitioner at liberty to raise the remaining grievances before the government by appropriate measures. In view of the submission so made, comma, the instant PIL is disposed of as withdrawn with the liberty platform.
I'm deeply obliged, my lord.
Item number 38.
Respondents counsel, yes.
May it please your lordship. Yeah, this is an appeal, my lord, against the finding of the appellate court of customs, my lord. My lord, what had happened in this case, my lord? One truck was confiscated. The truck was carrying some bags of rice. I am a.
Was carrying some
Bags of rice.
bags of rice.
And the confiscated item was some banned cough syrup. in the same truck.
Okay.
So my lord, the allegation against me was that those rice bags were purchased from me. Neither the truck nor the driver did belong to me. I'm a supplier of rice here in Guwahati, and for last 60 years, I've been supplying, dealing with the rice as wholesaler. So those rice bags, 360 bags were purchased on cash, by delivery of cash. I took cash, the bags were loaded. The driver himself in his statement before the authorities has said that it was unloaded, some 250 bags were there and rest of the bags were unloaded in some different godown. And from there, in connivance with another person, they loaded those banned materials. But on the basis of that, my lord, I am held liable, my lord, for hiding things under 114 of the Customs Act. And my lord, both the forums have found me guilty and confirmed the order, my lord. As against that, my lord, I am before your lordship.
Okay.
I may take your lordship to the, my lord, the show cause, my lord.
You are against the confiscation.
Yeah, no, against the, my lord, the penalty of 2 lakhs was imposed.
Okay.
It is against my reputation, man. He's a reputed businessman here in Guwahati. And my lord, 2 lakhs, this penalty would diminish my reputation. As against that, my lord, I had been contesting this case and I had no involvement in the matter. The driver has taken away the rice and somewhere else he loads some other materials. That is on record also, my lord.
Where is the original record?
My lord.
Where is the original record? Statements, etc.
If lordship require, I can produce it. That has not been called for yet. Because this
Record will be required in this
appeal
case.
is to be hard on substantial question of law.
That is all right.
If
We can,
lordship required, I can.
Mr. KL shall keep the original record available for the court's perusal.
If further one thing, the present appellant, he issued an challenge in favor of the form which was found to be non-existing.
That we have seen. Yeah.
I'll produce that.
List of supervision. Date दे देना यार 100 दे देना